Good morning, everyone. Thank you so much for being here. I'm letting everybody kind of trickle in. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to our Forms Update webinar. Our CEO, Chuck Kasky, and Legal Associate, Taylor Kitzmiller, are going to dive into our new forms and updated forms in just a moment. I want to let you all know that this webinar is being recorded and it will be shared. We do encourage your questions. We look forward to answering them. Please post all of your questions in the Q&A box below at the bottom of your Zoom screen. We are going to answer those after each form is reviewed, and then we will have time at the end of this webinar for additional unanswered questions. With that, I'm going to turn it over to Chuck and Taylor. Chuck, take it away.
Thanks, Kelly. We're going to wait just a minute or two. People are joining rapidly, so this serves as some an introduction and a welcome, but also a stalling technique. We're almost at 1,000 members now, and we have over 2,000 registered for today's webinar. So we probably won't just get over 1,000. So it's a new record for us, and that they're joining very, very rapidly. So again, welcome. I am Chuck Kasky, Maryland REALTORS CEO, with my colleague, Taylor Kitzmiller, Associate Counsel. And as you guys know, it's almost here. August 14th is coming. It's going to be I hope, I hope that it's not going to be too wild. The changes are substantial. Obviously, we're not going to minimize the importance of the changes that are coming, but we're going to try to keep it simple. Everybody knows the KISS method, right? And so we're going to try to keep it simple. Questions are already coming in. So good. I think that Taylor and I have been doing this enough so that we can anticipate most of the changes. Most of the questions. For example, the questions that I'm seeing already, we will be addressing them. Yeah. Yeah. Well, if our video and audio is breaking up, I think our connection is pretty good. It might be yours. So double check the strength of your internet connection. I don't think it's on our end. You will not see the questions. We see the questions. You don't want to see the questions, if you know what I mean. What we will do certainly is we will pose them, we will read them, and then answer them, okay? So, yeah, okay. So the connection on our end is good. We do see a lot of questions. Thank you for confirming that you're hearing us okay. Disclaimer, yes, all these questions so far that you've asked, we will get to, I promise. Good questions. Thanks for confirming. So I see a hand raised already. We're not going to, as a general rule, have people ask questions live. If you want to put a question in the Q&A, and then we'll review the questions. And if we wanted to convert someone from an attendee to a panelist so they can ask a question live, we might do that, but I would say probably not. So yes, all of these questions. Let's do this. Hold off on your questions. Let's see this. I haven't seen a single question yet. 14 open questions, although some were just comments, that we will not answer. Okay, so we already know the answers to all of the questions you have asked so far. So let's put a hold on new questions until, yes, open houses, yes, all of the questions so far we will answer. There hasn't been a single one that isn't in our standard presentation, and you can ask them in the moment, or we will answer them at the end. So for now, let's put a hold on the questions. So please, no more new questions. I promise you, every single question that has been asked so far, we will answer as part of the conversation and part of the presentation. I promise. If we don't, then that's okay. Certainly have you ask the separate question that we don't get to. But every single one, Taylor and I have been doing this for about a month now, sometimes 2 a day. I mean, we've been in literally dozens of offices in front of thousands of our members. And I can tell you, I think we've gotten all the questions we're going to get. So if you have something new, great. But it's been a while since somebody's asked a question that we haven't already received many, many, many times. So I think that's probably who is coming is probably already here. So with that, I will turn it over to Taylor to start. There are 5 new forms. So what we're going to be talking about today, 5 forms. That's it. Now, of course, I wish that was it. There are many, many nuances, many kind of iterations of questions. Let me just say, before we even start on the specific forms, that this has been a process. We went out, these were draft forms for 3-4 weeks. We started presenting them. We got very good comments back. I will tell you, we got really incredible feedback from you all. We know these forms even still are not perfect. They're in their 4th or 5th iteration, but they're going to be tweaked as we get more experience. And there's a couple of things that we frankly just don't know how they're going to play out because it's all brand new. So what we're going to ask of you, our members, is once you have experience with the new process, this new world where compensation's not on the MLS anymore, that we will need your input. How are the forms working? How's the timing working? What can we do to make it even better? And we're going to need to do that. There's no question about that. Okay. So with that, I will turn it over to Taylor. I'm going to assume before you start, Taylor, I'm sorry, false start, that everybody has at least a working knowledge of what's in the proposed settlement agreement between NAR, multiple companies, and the plaintiffs in the Missouri class action lawsuit. So we're not going to spend a whole lot of time talking about that really basic level stuff because we assume it's been out for what, 3, 4, 5 months now. So we hope that you have at least a basic working knowledge of what's in the settlement agreement that these forms implement. And the effective date again, August 14th. So with that, Taylor, take it away.
All right, thanks, Chuck. Okay, as Chuck said, we have 5 new and revised forms that we will be going through today. They are currently available on our website in their sample versions. They will remain as sample versions until August 14th, where they will be made available to everybody for use. They have already been provided to our form vendors with the instruction that on the 14th, they are to make them available to all of our members. So 5 new and revised forms. And we also have 2 amendments. One amendment for our buyer broker agreement, and the other amendment can be used for our listing agreements. Those 2 amendments are available for use right now. They are on our website that we have instructed the form vendors to make them available as soon as possible. So I've heard back from some form vendors that they already have published them, or if yours hasn't published it, they will soon. Those amendments, the purpose of the amendments are, if you have a current brokerage agreement with a client, let's say yesterday you signed a listing agreement with a seller, you can have your clients sign the proper amendment today or tomorrow, just before the 14th, and then come August 14th, the terms of that amendment will go into effect, amending your brokerage agreement to be compliant with the settlement agreement. If your client does sign that amendment, then on the 14th, you don't have to do anything. If they don't sign it, then on the 14th, you're likely going to have to terminate your old brokerage agreement and have them sign a brand new one that we provide to you if you want to make sure you are compliant with the settlement agreement. Okay, one other note. We have been asked from some members to make our listing broker's offer of cooperative compensation agreement available before the 14th. And we'll get to that agreement, but as a summary, that is the form going forward where brokers will agree to the amount of cooperative compensation, since that's going to be taken off the MLS. Our plan was to release that on the 14th, but we've had requests from members to release it before then, so agents aren't scrambling on the 14th to get that agreement signed. So that is our plan. We are going to let form vendors know likely today that they can release that as soon as possible. And we will also replace the sample version that is currently on our website with an official version that can be used. Okay. Let me share my screen and we will get into the changes. Okay. Now, Chuck, can you see my screen?
Yes.
Okay, great. All right, we are going to start with our exclusive buyer-tenant residential brokerage agreement. All the changes we have made to this form are contained in paragraph 8, which is our broker's compensation paragraph. The first change we made was to the notice section, and this change was specifically required by the settlement agreement. We've added in 2 sentences here. Each real estate brokerage independently sets their own commission rates, and commission rates are negotiable between the buyer and broker, specifically required by the settlement agreement for that statement to be in brokerage agreements moving forward. The next change we made was somewhat significant here. Paragraph 8A, compensation to be paid by buyer. This is the paragraph where the buyer and broker come to an agreement on what that buyer is going to be responsible for paying to that broker. So let's say X%. Currently, our brokerage agreement, this section here is just a blank paragraph. However, during this last legislative session, a new law was passed, which now requires brokerage agreements to state compensation in one of 3 ways. And that's these 3 boxes here: either % of the sales price, % of the sales price in a dollar amount, or it could just be a dollar amount. So no longer having that blank paragraph. When you're sitting down with your client, you're going to click one of these boxes and fill it in accordingly. So we've also added in here, subject to paragraph 8B, in the event of a sale or lease, the compensation to be paid by buyer to broker shall be, and then they're going to select one of these options. So again, this is where the buyers agree to compensate their broker, whatever is entered into here. But we also added in this, subject to paragraph 8B, that might not be the case. So we'll go down to 8B. So 8B is compensation paid by listing broker or seller. Broker is authorized to receive compensation from the listing broker and or seller. So some of this language was already in our brokerage agreements, but we've really flushed it out. And the goal of this paragraph is to explain very clearly to the buyer, depending upon the situation, what happens in your transaction, you might have to pay that full amount to your broker that you agreed to above. You might have to pay some of it, or you might not have to pay any of it to your broker, depending upon what happens in the transaction. So, first, property listed in the MLS. Compensation may be offered from the listing broker to broker through an offer of cooperative compensation. Broker shall attempt to secure an agreement for the amount of offered compensation from the listing broker prior to submitting an offer to purchase. So this is somewhat referencing a new form that we have, which we will get to. And in that new form, it allows the brokers to come to that written agreement for the amount of cooperative compensation. And what this sentence is saying is the buyer broker or buyer agent has to make an attempt to secure that agreement in writing before their buyer submits an offer. Mainly because it is in the best interest of your buyer to know, okay, this property is offering cooperative compensation. And maybe they're offering enough to the point where that buyer's not going to have to pay their broker anything. Or the opposite, maybe they're not offering any compensation, and your buyer needs to know that, or they should know that before they submit an offer on the property. Now, we've received feedback from our members, which caused us to tweak this sentence to how it is right now. And the question was, well, what if I try to contact the listing agent to get this agreement in writing, but they just don't respond for whatever reason? And it's a timing issue, and my buyer really wants to submit their offer. As long as you make your attempt and reach out to that listing broker, you are complying with this sentence. So if you make the attempt and they don't get back to you, your buyer is free to submit their offer. The amount of compensation received by a broker from a listing broker shall be credited against the compensation that buyer has agreed to pay broker in paragraph 8A, which is that above paragraph that we first talked about of this agreement. Except as provided below, if the compensation offered by the listing broker to broker is less than the compensation buyer has agreed to pay broker in that above paragraph, buyer shall be obligated to pay the difference. So what that's saying is, if that in that above paragraph, if buyer and broker agreed, okay, buyer, you are going to pay me X%, and the offer of cooperative compensation is Y%, which is less. That sentence is saying if that buyer moves forward and purchases that property, the buyer is responsible for covering that difference, for paying their broker whatever that difference is. If the amount of compensation offered by the listing broker to broker is equal to or greater than the compensation that buyer agreed to pay broker in paragraph 8A of this agreement, buyer will not have to pay the compensation specified in paragraph 8A. So that's saying, buyer, if you agreed to pay broker X% and the offer of co-op is Y%, which is equal to or could even be greater, buyer, you're not going to have to pay your broker that amount noted above. This next sentence in bold, specifically required by the settlement agreement and is a complete 180 from what our brokerage agreements currently state. It says, broker is prohibited from receiving compensation from any source exceeding the compensation amount specified in paragraph 8A. Currently, our brokerage agreement states the opposite. It says if there's any excess compensation offered that exceeds this amount agreed to by the buyer, the broker gets to keep that excess amount. Now the settlement agreement specifically prohibits that broker from receiving excess amount. Chuck, do you want to touch on some of the questions we've got surrounding that?
Yeah. So, well, first of all, the final paragraph is important because this paragraph up here, and again, I'm already going to show you some of the things that we probably will need to tweak, because when we talk about here about cooperative compensation, it should also probably reference that there is another option. So if the cooperative compensation offered by the listing broker is less than what the buyer's agent has agreed to work for, the other option is to request the difference from the seller as opposed to just assume the buyer's going to pay it, right? So that's just a little.
So we do address that down here, but
that's my sign. They probably should be closer so that, you know what I mean? So
yeah.
we are learning. These are going to be tweaked. What I would say is, and when we get to the buyer side, these are all going to be part of what we expect that these conversations you're having with the buyer about the sources of your compensation. Okay. Now, but if you go back up to 8A for a moment on compensation, two things. Another thing that we learned, if you could scroll up, Taylor, to the compensation.
Yeah, I'm on 8A.
Okay. So a couple of questions that have come up in the chat in the Q&A, but also that we've received. One thing, the first thing is, in paragraph 8, this is the total compensation. And so when we get to cooperative compensation, that will be a different conversation. And so this conversation on the listing agreement will be different, right? Because the question is this compensation just to the broker, and is it total compensation that includes cooperative compensation? But that's a conversation we're not going to have right now. We're going to have that in context of the listing agreement. Okay. The other question we get is this flat fee amount. And there's a question about admin fees. And our position on admin fees is there is no such thing. We've been talking about this for about 15 years now. RESPA and the Consumer Protection Bureau, the CFPB, says very specifically, who enforces RESPA, that what is provided here is compensation. There is no reason to call, if you have a percent of sale price and you charge a separate flat dollar amount, we are recommending in the strongest terms possible that you don't call it anything except compensation. And the point is that there were some enforcement actions a few years ago by the CFPB that asked brokers who charge this quote unquote admin fee, what do you do for that? And how do I know as a consumer that, number one, what services are you providing for me that is not compensation for my representation, but are for something else? And if it is for something else, you need to prove to me as a consumer that whatever you charged me, I understand what it paid for, and that it's reasonable for those things that you claim are being paid for by this quote unquote admin fee. And I've heard things like, well, file maintenance and technology upgrades, or whatever it is, this list of things that you think that goes to pay for, I'm going to go ahead and guess that you probably can't tell me what those are and have to defend that those are reasonable charges for that thing that you purportedly do for that fee. So we've been recommending for at least 15 years that we stop using that term, that you use the word compensation. And because there's no need to describe it as anything but percent of sale price and a dollar amount. Full stop. It's your compensation. So please stop using the phrase admin fee. It's compensation. Percent of sale price and a flat dollar amount, period. Okay. That's all I have.
Okay, great. All right, so moving on here. The amount of any such payment made by listing brokers shall be with the seller's and buyer's prior knowledge and consent, and shall in no way affect the obligation of the broker to act on behalf of the buyer in the transaction. If the compensation offered by the listing broker to broker is less than the compensation buyer has agreed to pay broker in that above paragraph, buyer may include in the offer to purchase a request that the seller compensate broker in an amount equal to the difference between the compensation in paragraph 8A and the amount offered by the listing broker. So that's saying, buyer, if you agreed to pay your broker X percent, the offer of co-op is less at Y percent. When you submit your offer, you can use a new addendum, which we'll pull up in a second. You can use a new addendum requesting the seller to compensate your broker in the amount of that difference. And if they agree and it's equal to, then that buyer's not going to have to pay their broker anything.
So the operative phrase there is may, right? And this is like 4 or 5 questions that have already been answered or asked, excuse me. It may. Now, there are other options, okay? This goes back again to, the conversation that you will have with buyers, right? And a lot of this is going to make sense when we talk about the options that are available at that point. If you agree to compensation that's X and the compensation is Y, I'm sorry, can you go back up just a little bit? Okay. So if you agree in the buyer broker agreement, you're going to have this conversation with the buyers. That's where it starts, right? So that conversation with the buyer has to be along the lines of, look, there may or may not be cooperative compensation. There may or may not be an agreement or the ability to seek compensation from the seller. Ultimately, you, the buyer, could be responsible for some or all of the compensation you are now agreeing to pay me and my broker. That is a conversation you absolutely must have at the very beginning. And you have to identify the 3 sources of compensation, potentially. The listing broker through cooperative compensation, the seller through concessions that Taylor's going to get to, and ultimately the buyers themselves, potentially responsible for some or all of your compensation, right? That's the conversation right out of the gate that we have to have with buyers. And to take a step back, bigger picture here, that's what the DOJ wants, right? The Department of Justice, the consumer advocacy groups, for some reason, we won't get into that, we don't have that kind of time. Their vision for this industry is very simple to explain, and they've been very clear. The DOJ wants sellers to hire their brokers and pay them, buyers to hire their brokers and pay them. That's their vision for this industry. And they've been allowed, the DOJ that is, to reopen their investigation of these practices. The courts just allowed them. Even though there was a settlement agreement with NAR, the DOJ reopened that investigation and the courts just recently allowed them to do that. So we need to keep these big picture stuff in mind when we're talking about why this is happening, right? This is happening specifically to avoid steering. And that means the practice of having agents tell buyers about properties because based on the compensation the buyer's agent would receive, as opposed to what's in the best interest of the buyer. That's the entire purpose here. And to get in this incremental step, ultimately leading to buyers paying their brokers, full stop, okay? So you got to keep these bigger pictures in mind. And the question's gonna come up, and it has already, builder bonuses and other things like that. So it says right now, brokers cannot receive compensation from any source exceeding the compensation in 8A. So actually, before we get to that, can you scroll back up, Taylor? I just want to share.
To 8A.
8A, yeah. So it says to be paid by buyer, and then again, down below, it says, hey, but there are other sources of that compensation. Not only does this, if this is a flat dollar amount, just stop and say that, but we also get a lot of questions, two things. The first is, can this be a range? Like, let's say they might be interested in new construction. Can I put in here percent of sale price and any bonus that I might get from a builder, for example, if they're looking at new construction? And the answer is no. It's extremely important that compensation in the written buyer agreement must be, and these are the words directly from the settlement agreement, objectively ascertainable and not open-ended. So we eliminate that all, what used to be per MLS or whatever, that all is history. This is the biggest job we have now as buyer's agents to discuss and explain compensation to buyers in a way that they can understand, starting with what you get paid, how you get paid, and the three potential sources of compensation up to and including the buyers themselves. Okay? If you scroll down again to B, two things real quick. May not receive compensation from any source exceeding the compensation in 8A. Questions here have been along the lines of, what if it's less? And what if it's more, right? And I'm going to lump those two together because in that example, and Taylor already said it, well, on the other side, if there is cooperative compensation, what if it's more than what I agreed to? Let's say the buyer came in and talked me into, and I agreed to compensation, and then turns out, we find out that the listing broker's offering cooperative compensation in an amount greater than what's in 8A. That raises the question of amending the buyer representation agreement. And our position on that is as follows. I'm going to preface this by saying I'm sorry, because I like to give yes or no answers, and I don't have one. We do not have a yes or no answer to that question. Keeping in mind the reason for this, to avoid steering, to eliminate steering, if there is compensation offered or available to you that's greater than the amount offered in paragraph 8A as the buyer's agent, whether it's a selling agent bonus or a bonus from a builder. Our position as of today is this: the settlement agreement does not expressly prohibit amending the buyer representation agreement. It does not. Up or down. The choice for you is whether you want to approach the buyer and say, there's an opportunity here for me to get a bonus from the builder for representing you in the purchase of this house. If your company policy, and this has to be a company policy that is approved by your company's legal counsel, if you want to have a conversation with a buyer about amending that agreement so you can accept an amount higher than what's in paragraph 8A, the only position at Maryland Realtors as of today is that is not expressly prohibited by the settlement agreement. We're all going to figure out about whether that's a good idea or not. We are taking a very conservative approach, again, understanding the whole reason behind this, number one, and the fact that all eyes are on us. The DOJ would like nothing more for us to exploit all kinds of loopholes and conduct business as usual in spite of the settlement agreement. Because bottom line here is it is still only a proposed settlement agreement. And if the court, and this judge specifically who has control over whether the settlement agreement gets final approval, is not our friend. And I'm here to tell you, there is a world in which by the end of the year or early next year, this settlement agreement is not approved. And then we think we have a lot of work to do now. What if we had to throw everything out and start all over? And I'm not predicting that. I'm just saying the more we poke holes in this and the more we find workarounds, that's just going to get their attention. And we should be very, very cautious about doing that. So keep those things in mind. If you are anticipating a situation where you want to amend the buyer representation agreement to allow you to receive an amount higher than is in paragraph 8A that you negotiated with the buyer, first of all, think about what that negotiation with the buyer looks like and feels like and what their reaction would be. And second of all, ask yourselves if that's a good idea from a policy perspective. Only your broker and your broker's attorney can answer that for you. Okay?
All right. We can wrap up a few more changes here. So property not listed in the MLS, this language is almost identical to what our brokerage agreement currently states. Property not listed in the MLS, broker shall disclose to the seller at first contact that broker represents buyer and shall provide written confirmation of the disclosure to the seller not later than execution of any purchase or lease agreement. And broker shall make any request for compensation from the seller at first contact. And the final change we have is we've added in an initial section for the buyer to acknowledge that they have read and understand the provisions of paragraph 8, the full compensation paragraph. Okay. Next form we're going to go over is that addendum that we were referencing, which is called the buyer request for seller's compensation of buyer's broker addendum. And remember, this can be used when the buyer has agreed with their broker, I'm going to pay you X% as an example, and the current offer of cooperative compensation is less than that, let's say Y%. And this is where the buyer can request the seller to cover the difference. So first paragraph here, prior to the execution of this addendum, listing broker has agreed to pay buyer's broker an offer of cooperative compensation in the amount of X, which is the broker-to-broker compensation. So, as I referenced earlier, the buyer broker should attempt to secure that agreement for cooperative compensation in writing before the offer is submitted. And I think majority of the time that is going to be the case. So, if the brokers have that agreement, and let's say they agree to that Y%, you would just put in here Y%, whatever that agreement is. In the second paragraph, actually, before I move on, the question we get is, well, what if I don't have that agreement before we submit our offer? If in that scenario where listing broker just hasn't responded to me and my buyer really wants to submit their offer. If you don't know what that amount is, and remember, your buyer has agreed to compensate you X%, you could put in 0 here, and then you could put in that requesting the seller to compensate your broker, the buyer's broker, that full X% here. And if the listing agent, gets this offer and realizes, oh no, we are offering cooperative compensation, they send that agreement over to the buyer broker and they come to that agreement, then this amount could just be amended to accurately state what that agreement is between the brokers. But majority of the time, you're going to know what that amount is. You're going to put it in paragraph 1. And then in paragraph 2, in addition to any broker-to-broker compensation, the seller hereby agrees to pay buyer's broker the amount of X. That is where the buyer is requesting the seller to cover the difference. Paragraphs to point out here. Paragraph 4, seller hereby authorizes the settlement agent to pay buyer's broker the sum of paragraphs 1 and 2 above at settlement from the proceeds of the transaction. So just saying whatever the offer of co-op is here, plus whatever amount the seller agrees to pay in addition, that full amount is going to be paid to the buyer's broker at settlement. The other paragraph to point out here is paragraph 6. Lenders may specify limits on how much a seller or broker can contribute to the buyer to pay for services traditionally paid by the buyer. These payments are called interested party contributions, or IPCs. I'm sure you're all very familiar that lenders have these IPC caps that they place on a buyer, where that buyer can only receive a certain amount for services that are traditionally paid by the buyer. However, because offers of cooperative compensation are traditionally paid for by a seller or seller's broker, it is the intent of the parties that the amount in paragraph 4 should not be treated as an IPC. So lenders have stated, as of right now, they will not be treating compensation of the buyer's broker as an IPC. Therefore, whatever that amount is, is not going to count against that buyer's IPC cap. So we've included this paragraph in here as kind of a heads up to lenders that, hey, lender, the amount that's agreed to here is going to the buyer's broker to compensate the buyer's broker. Therefore, it should not be treated as an IPC and shouldn't count against that buyer's IPC cap.
So some of the questions are anticipating what we're going to be talking about on the listing side, right? So we're talking about cooperative compensation, we're talking about requesting closing help, or et cetera. So this particular, go up to the top again, Taylor, real quick. So this anticipates that there's co-op. Oh, this is for sellers. Oh, yeah. This anticipates that the listing agent has made you aware that there is cooperative compensation, right? So we're a little ahead of ourselves because we haven't even talked about that yet, right? So just know that we'll catch up. And I'm wondering if maybe we should go to the listing side first. But
yeah, we're about to go to the listing agreement.
Yeah, let's keep this in mind, and we'll go, because these are all puzzle pieces, and the questions that I'm seeing are anticipating what the conversation has been with the seller, because this form's only necessary if the seller has agreed the listing broker offer cooperative compensation. The other options, if there's not, are the concessions, and then ultimately the buyer. Remember the three sources of buyer broker compensation. So you first of all have to know, is the listing broker offering cooperative compensation, right? Before you would even initiate this form. Is that right?
Right. Well, there's that rare, and I think it's going to be a rare scenario where the buyer broker and listing broker have not agreed to that amount of co-op before the buyer's offer is submitted. In the rare scenario where they haven't agreed to that amount, that's where the buyer can submit this addendum and say, okay, it's 0, and then request the full amount of compensation here.
And that's assuming no cooperative compensation.
Right. Or
Right.
if they don't know what that amount currently is, if the listing broker hasn't responded to the buyer broker.
I think maybe we should just switch gears a little bit. Let's go to the listing side first.
Yeah. Listing agreement's the next form here.
Yeah. So yeah, talk about that, and then we'll, I think, fill in some of the blanks from the questions that I'm seeing.
Okay. All right. This is our exclusive right to sell residential brokerage agreement. Almost all the changes you see here will be made to the exclusive right to lease and exclusive right to sell on improved property brokerage agreements. First change here, not a substantive change, really just a language preference. We used to refer to the duration of the listing agreement as the listing term. Now it is referred to as the agreement term. So remove listing term, and now it's agreement term, and that's the same changes that you see down here. Okay, the next few changes that we're going to go over were made in response to Bright MLS policy changes. The first change that we address here, Bright, come August 14th, is going to require a new form to be submitted to Bright, and that new form is called the MLS Disclosures and Residential Seller / Landlord Options Form. Essentially what that form is it requires the seller to state when the property will be submitted to the MLS, on what date, and in what status the property will be submitted, active, coming soon, or office exclusive. So Bright is going to require that form to be submitted come August 14th. They also are going to require it to be filled out and signed, agreed to by the seller at the same time as the listing agreement. So we've added in this sentence kind of as a heads up to the agent or broker and their client that they're going to need that form. So we state here, upon the execution of this agreement, seller and broker shall establish the date and status upon which the property will be entered into the MLS by executing that form, the MLS disclosures and residential seller / landlord options form. Next change we have here, not really a substantive change, just language changes here. We've added in a header, office exclusive. This is our office exclusive paragraph, but we didn't previously have a header, so we've added that in. The rest of the changes were wording tweaks by Bright, and I talked to Bright. The wording changes, it didn't change, how the office exclusive rules work and are applied. So previously, they said seller may elect not to have the property listing displayed on the MLS at all, but they've changed displayed to distributed on the MLS at all. Previously, we also said broker may not submit and market the property by and through display on the MLS during the listing period. The reference to the broker may not submit the property to the MLS was not accurate. You still have to submit the property to the MLS, but you're just submitting it as an office exclusive. So we've removed that reference to you don't have to submit. You do still have to submit the property as an office exclusive. Okay, next change is to our coming soon paragraph. The main change here, Bright used to have a restriction that if you put a coming soon listing on the MLS, the agent would have to enter an expected on market date that could be no later than 21 days from when that listing was submitted to the MLS. Bright has now removed that 21-day restriction, and now a coming soon listing can stay in coming soon for as long as that seller wants. So we have removed that reference to the 21-day restriction here. We also used to state that all MLS subscribers properties listed under the coming soon status may not be shown. That's still true. But we used to say, and are not syndicated to public real estate websites. That is no longer the case. So coming soon listings that are provided to Bright can be syndicated to public real estate websites. And the final change, since we have that removal of the 21-day restriction, we've changed this sentence. Coming soon listing status is an option for properties listed in the MLS that are not available, but will be in the future instead of will be soon, because there is that no longer that 21-day restriction. So in the future is a more accurate term there. Okay, final change that we made to our listing agreement because of Bright changes. Bright has created a brand new seller concession field on Bright. What this field does is it allows the seller the option to notify potential buyers whether that seller is willing to consider requests for seller concessions. There's two main things to note about this field. First, it is optional, meaning your seller doesn't have to fill in any information here. They don't have to click yes or no or fill in an amount. They can leave it blank. And number two, this field is non-binding upon the seller, meaning if the seller clicks yes, they will consider a request for closing costs. And if they even go as far to come down here and say, I will consider up to X% in closing cost or seller concessions. Let's say they put in X%. And a buyer sees that, buyer makes their offer initially requesting X% in concessions. This is not a binding field upon the seller. Therefore, at that point, the seller can say no. They're not obligated to provide whatever they fill in here. So let's look at the actual field itself. So the seller really has three options here. They can say yes and just leave it at that. They can say no and just leave it at that. Or they have the option to say yes and come down here and specify a certain percentage or dollar amount.
Or leave it blank.
Exactly.
said,
Or
it's
it's an
non-mandatory
optional field. You
Right.
can leave it blank.
Right.
And
anecdotally, I can tell you, Taylor, maybe your experience is different. Regionally, some buyers or some sellers, I should say, can anticipate a buyer request for concessions. In some markets, as I travel around the state, they are pretty rare. And so we don't have the data from Bright as to, I mean, this has been a month. It's been out and in Bright for a month. So, you would be able to tell us better than, we don't know, except what you tell us. And Bright hasn't shared any data. How many sellers are actually checking one box or just most sellers, from my understanding, are just leaving it blank. Okay, so, but it's there, it's available. It just doesn't seem to be used all that often. Okay, so let me just editorialize a little. If you could scroll up to and actually shrink this just a little bit. Hopefully people will still be able to see it. I think the important part here is the compensation. So go down to compensation. And try to get, compensation, cooperative compensation and concessions on the screen at the same time, if you can. So 14, 15, and 16. Because this is the new conversation with, and if you can't, that's okay, but just follow.
Yeah, I'm not gonna be able to.
So once you establish compensation, right? Paragraph 14 is total compensation. And I think one of our first tweaks is gonna be to ensure that everybody understands that paragraph 14 is the total compensation sellers will be paying, especially if they are offering cooperative compensation. And this has come up a lot. So if you're offering X percent, or I should say, you have agreed and the seller has agreed to pay you as the listing broker X percent, and then later on agreed to cooperative compensation for some percentage of that compensation, that doesn't change the amount in paragraph 14. Okay, so think of paragraph 14 as total compensation, from which cooperative compensation in paragraph 15 will be paid to the buyer's broker. Okay, so let's be clear about that. And when we redo the forms in whatever time frame we do, we'll make that explicit in paragraph 14. So I've gotten that question from a lot of people, and we can improve on that. But think about that when you're filling out the listing agreement. Think of paragraph 14 as total compensation. And if there's cooperative compensation, that will be part of the total compensation from paragraph 14. Okay. So the next option is fill out paragraph 14, and these have to be talked about at the same time, because if there's compensation agreed to in paragraph 14, and the seller says, no, I am not willing to compensate the buyer's broker through cooperative compensation, then our job is at the very least to explain before they make that decision. And this is really important. So if you can go to the cooperative compensation paragraph, Taylor. What's hypercritical here is that when seller is going to make that decision, am I going to compensate the buyer's broker? Before they make that decision, it's our job to make sure they understand when they go to make that decision, they are making an informed decision. An informed decision means that I know the pluses and the minuses, the pros and the cons of what I am about to do. Because every decision I make probably has consequences. Some are positive and some are negative. And I see in the Q&A a lot about first-time buyers who are struggling to come up with cash, right? So we have the conversation with buyers that, hey, there could be times, if this is the house you want and I am not getting compensated from either the listing broker or the seller, that you're going to owe me that difference at settlement, means you're going to have to bring extra cash to close. That's a big part of the buyer's decision, right? And so you're going to have listing agents are going to have this conversation with sellers about the pros and the cons, the consequences, plus or minus, of offering cooperative compensation. So, depending on the negotiation on paragraph 14, that number might be different if the seller's offering a co-op. It might not. That's up to you and your company policy. But if they decide to not, and then they negotiate, let's just say, a lesser amount in paragraph 14, then their net is going to go up, right? They're going to make a little more money on, or maybe a lot of money, depending on the sale of that property. On the other hand, they may be limiting the prospective pool of buyers. And they should anticipate in many markets that if they're not offering compensation through the listing broker, that it's likely, again, depending on the market, depending on the price point, a lot of variables, it's at least conceivable that the buyer will be seeking compensation through seller concessions. And so that's why the compensation paragraph, the cooperative compensation paragraph, and the seller concessions paragraph all have to be discussed at the same time in a way that makes sense so the sellers can make an informed decision. That's a big job. We know that. This is new. This is different than what we are used to doing. So I hope that makes sense. Let me just say one more thing. If the seller decides, hey, I understand that, and if I bought this house, when I bought this house that I am now selling, I'm pretty sure I didn't pay you. I'm pretty sure the listing broker paid you. And so I've had conversations with listing agents that have said to sellers, hey, this model worked for you. So, how does that, what's changed in the marketplace? And shouldn't you at least consider cooperating the buyer's agent just the way I got compensated by the buyer's agent? And in the specific scenario I'm talking about, these people did represent the seller when they bought this house. So they were repeat clients, and it was fine for them as sellers at the time. And that's just a script that you need to have. What are you going to say to sellers to describe the pros and cons of offering this co-op? Okay. Now, and also say, look, by the way, as I've mentioned earlier, if you don't offer a co-op, be prepared to at least potentially see in the offer a request that you compensate the buyer's broker anyway. The real thing here is, as of, if you go August 13th and you pull up a listing, you're gonna know what the co-op is, right? If there is one, and if so, what there is. When you pull up that exact same listing on the 14th of August, that's gone. So number one, I'd print out, if you're working with a buyer and you have already seen some listings and there was a co-op offered in Bright on the 13th and it's going to be gone on the 14th, I'd print that out, right? Because it's going to be gone off of Bright, and the way this is legally binding is going to change. And so what I want Taylor to talk about now is how we deal with two types of listings, right? So if I'm the buyer's agent and I pull up listings that the buyer's interested in, right? Let's just make it simple. Say there's four listings. They've told me what price range, how many beds, how many baths, etc. So I pull up 4 listings that meet their needs. How do I know if there's cooperative compensation on August 14th? Because it's not on the MLS anymore. So here's what you need to start thinking about if you haven't already. How am I going to communicate that offer of compensation to buyer's agents when I don't have the MLS to do it? And the answer are there are many ways to do it. first and foremost on your website. That's the most obvious way to do it, because that's probably where listing agents, that might even be where the buyer found out about this property, right? Because we know that they do a lot of research first. They may already be familiar with that property, probably already seen the website. So now option number one seems to me is put it on the website. If there is cooperative compensation being offered by the listing broker, you need to communicate that to buyer's agents. And the first way we think could do that is using the website. Bright has said that if there is a URL that you can point buyer's agents to, you can put that URL in the agent remarks in Bright. Just the URL, and only in the agent remarks, not the public remarks, in the agent remarks. That way, the buyer's agents can find that property, and on that property for that listing, you can say offering a co-op. We are not taking a position about the business practice of whether you want to disclose what that is or not, right? We are just saying that you can make that known to buyer's agents on the website. You will have to decide whether it's a good idea for the seller to share what that is or not. We're not taking a position on that. But you can also put it on your social media feeds. Hey, check this out. Check this out. You can put it on a sign writer, offering a co-op. The settlement agreement only prohibits us from sharing that information on the MLS, directly or indirectly. So it can't be uploaded to it's not a disclosure. It can't be in showing time. But as long as it's not indirectly or directly communicated through the MLS, it is not prohibited by the settlement agreement. So start thinking about that. The other thing is, if you're the listing agent and there's a co-op, buyer's agents are going to call you. They're going to reach out. And I've had, in meetings, I've had, 50, 60, 100, 150, 200 people, and people say, buyer's agents say, well, how am I going to know? If I go to the website, okay, maybe it's not there. I call the listing agent, and then what? And there's usually, when I say, oh, well, you just call the listing agent, there's chuckling, and because listing agents have a reputation, I could say, of not being as responsive as they should. That buyer agents call a lot and say, I'm frustrated. I've reached out to the listing agent for this information and I never heard back. So one of the things we really have to do, please, 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 listing agents, be responsive. You are gonna be contacted by buyer's agents that want to know if there's a co-op, and if there is, how much it is. Please respond. You do not represent your seller client adequately if you're not responsive to requests from buyer's agents regarding cooperative compensation. So please, please, please keep that in mind. And we got to do better, frankly. Okay. So you want to talk about concessions, Taylor, or you have anything else on that?
The only other note I had for the concession field here, like we said, it is optional, meaning there could be a scenario where your seller doesn't fill out any information. But even if that is the case, you still have to make sure that they initial at the bottom of the paragraph. So whether they fill something in or not, they always have to initial that they have read and understand the provisions of paragraph F here.
So stay on concessions for a moment. I've gotten a couple of questions about being optional and non-binding. How do buyers know it's not binding? Well, because it says may. The words here will consider, seller may elect,
Also,
is willing
right here,
to consider. Yeah.
seller's
And so-
indication, willingness to consider
Yeah.
seller concessions on the MLS is optional
Yeah.
and non-binding.
So all of the language of this paragraph should give you the indication and very expressly that the seller, to the extent they're going to use this field, and I have no reason to believe that all of a sudden sellers are going to start using this field, right? So let's just take this flow, right? Because remember the three sources of compensation: cooperative compensation, seller concessions, buyer, right? So now you're talking to the buyer. And let me go back to my scenario about the listings, right? So I got 4 listings. On 2 of them, I go to the website, I call the listing agent, and I know there's a co-op, right? So I put that aside. I got 2 listings and there's a co-op. I know what it is. We won't talk about whether it's the same as what's in the buyer representation agreement or not, but let's assume it is. In that case, that's when you would use the agreement between the listing broker and the buyer's broker to compensate, right? That is the, you want to pull that up real quick? This is the listing broker's offer of cooperative compensation. And the reason this is important now is because this takes the place of the agreement that is reached by us through the MLS, because that creates a contract. It's an offer that I accept. The listing broker has made an offer of compensation that I accept by procuring the buyer. That's a legally binding contract. That goes away on August 14th, and it has to be replaced by something. And this is what replaces it, okay? This now serves as a binding agreement, contract, if you will, between the 2 brokers for compensation. It's pretty simple, and that's those other 2, okay? So if we go back to the listing agreement real quick, and we'll go dive deeper into this and take some questions on it, but I want to touch on these. So now that's if there is cooperative, if there's a co-op. If there's not, and as you already explained to the buyer, hey, seller concessions is an option. So let's assume that this field is blank, and which most likely it's going to be blank. So you go to the buyer and you say, on these 2 listings over here, guess what? I have 2 over here, and that cooperative compensation has been expressed. So I have some certainty on how much compensation I'm going to get from the listing broker. On these 2, there is no cooperative compensation, and the seller concession field is blank. So seller concessions are an option. What do you want to do, buyers? Do you want to, number one, still see this house? And if you like one of those 2 houses, just understand that we can make in the offer, you can include a request for seller concession.
Using this addendum.
Or the other one, right? So now there are 2 types of seller concessions. Taylor's going to explain that to you. But and while Taylor's explaining the forms in detail to you, please understand, because I've had follow-up questions about IPC, so you're probably going to have to go over that again, that there is less certainty, right? And the buyer's going to have to understand, look, for these 2 properties, you can include request for seller concessions to be used to pay my compensation, but unless and until we're under contract, you're not going to know what that is. We are not going to know how much, if any, the seller's going to offer and come in a concession to pay my commission. And as we discussed very early on, you will be asked to make up the difference as the buyer at settlement, and you may need to bring extra cash to close. So this is now the new conversations we have to have with buyers, and we have to be prepared for this because it's 2 weeks away. And starting soon, these are the new conversations we're going to have with buyers. So again, Taylor, I'll launch you. Let's assume no cooperative compensation. It could be that the offer of compensation is less than what the buyer owes me, and you can use seller concessions to make up the difference, right? That's okay too. But let's assume, for sake of simplicity, that there is no co-op on these 2 properties. I explained to the buyer, you can request seller concessions. And there are 2 types of seller concessions that Taylor's going to go over now.
So Well, the first seller concession would be using this addendum, requesting the seller to directly compensate the buyer's broker. Or, and this is, we're getting a little ahead here, or the buyer could just use our seller contribution addendum and request a seller concession that way. I think jumping ahead is just going to cause more confusion. I think we should finish out with the changes to the listing agreement
Okay.
first,
Okay.
and then we'll get to that. It'll make more sense. Okay, we'll just wrap up the changes here. The changes to the compensation paragraph directly mirror the changes to the buyer broker agreement compensation paragraph. So the notice section, we've added in those 2 sentences here, and the spot where the seller agrees to the amount of compensation, that blank paragraph has been removed and replaced with these 3 options. And like Chuck said, whatever amount is agreed to here is the total amount. So let's say X%, that's the total amount that the seller is agreeing to compensate their broker. Then down in paragraph 15, which I'll explain some of the changes, but paragraph 15 is where the seller has the option to authorize their broker to share cooperative compensation with a buyer broker. And if they do so, then remember that full amount was X. They can say, okay, well, I authorize you to share Y, which is, let's say, a portion of X with a buyer broker. So full amount in paragraph 14, anything taken out of that full amount and offered to a buyer broker is in paragraph 15. Okay, paragraph 15, the specific changes. It is now authority to cooperate with and compensate other brokers. Most of these, actually all these changes really aren't substantive. They're more so language changes. It now states broker is authorized instead of shall be entitled. So broker is authorized to cooperate with other brokers as subagents of broker and or brokers retained by prospective buyers to represent buyers' interests. We also used to reference cooperation and compensation between buyer agents, but cooperation and compensation is between brokers, not agents. So now it's accurately stated buyer brokers. Also, we've kept in mind for all of these changes to try to make our brokerage agreements as plain and easily understandable to clients as possible. And we realize that, we reference cooperation here, but an unrepresented or first-time home buyer, first-time home seller, they're likely not going to know what cooperation means. So we've added in the definition here. Cooperate means sharing information on the property and making the property available to other brokers for showing to prospective purchasers. The final change, we removed the term fee sharing with subagents or buyer brokers with the more accurate term compensation of subagents or buyer brokers. And the last change, we've added in the sentence here, seller understands that compensating subagents or buyer brokers is optional. Okay, that is all of the changes to our listing agreement. Now we will go to that listing broker's offer of cooperative compensation agreement. And remember, this is the agreement since offers of co-op are going off the MLS on the 14th. Moving forward, if you want to have an agreement for cooperative compensation, you need to be using this form because it's going to create that valid, enforceable, contract between brokers.
As so I'm sorry I got ahead of us, and there was a person that said we're making it worse. So apologize for that. I did get ahead of him, but we can go back over some stuff now that we're where we need to be.
Yeah, no problem. Actually, before we dive into this form, I'm kind of building upon what Chuck said. The settlement agreement specifically prohibits offers of cooperative compensation from being 1, on the MLS, and 2, on any platform that takes a data feed from the MLS. ShowingTime, as an example, like Chuck said, takes a data feed from the MLS, so you can't put offers of co-op on something like ShowingTime. The exception is broker's website. If that takes a data feed, that's fine. That broker can advertise cooperative compensation on that broker's listings only. But outside of those two restrictions, it can be anywhere else. It can be on your social media, on a sign. You could leave a sign at an open house. Anywhere else, you can advertise your offer of co-op. And the second thing I want to get into before we look at the specific details of this form, a question we get often, and I think it was maybe the first question asked in this webinar, is about subagency. Is subagency going away? The answer is no, it is not going away. It's going to be an option just as it is today. But there's some things to know moving forward. So ideally, it is the best situation if you're approaching a prospective buyer, as you know, you want to be that buyer's agent, is to have that buyer sign a buyer brokerage agreement with your brokerage. That way you can guarantee your compensation, at least from the buyer. Obviously, we talked about, buyer can be compensated, or the buyer broker can be compensated from other resources, but you're guaranteeing your compensation if the buyer signs that agreement. But in the scenario where you try to get the buyer to sign that, but they say, no, I don't want to sign anything, that's fine. You can move forward as a sub-agent just as you do today, which means providing that unrepresented buyer with the understanding whom agents represent for. And NAR has stated that having that unrepresented buyer sign that form satisfies the requirement to have a written agreement before showing that buyer a property. So at that point, if they sign that understanding whom form, at that point, just like today, you become a sub-agent and you are assisting that buyer. You're not representing them, you're representing the seller. But since offers of co-op are going away from the MLS, you need to make sure that for that property is compensating sub-agents. Because if they're not offering cooperative compensation to sub-agents, and you're assisting that buyer for that property, you're not going to be compensated if they don't agree to compensate you as a sub-agent. So it's really important to confirm before you start assisting that buyer for the property that you will be compensated by that listing broker through an offer of co-op. Okay. This form specifically, as we noted at the top, this form shall not be uploaded to the MLS. It would be a violation of the settlement agreement because this discusses offers of cooperative compensation. Okay, we'll just go through this line by line. This agreement serves as confirmation of the cooperative compensation offered by listing broker to buyer brokers or sub-agents in relation to the sale of the property noted above. The listing broker shall pay the cooperative compensation to a buyer broker or sub-agent who completes performance specified herein, and seller acknowledges that the offer of cooperative compensation is fully negotiable and not fixed by law or established by any membership organization with which listing broker is affiliated. Okay.
Could you enlarge this, Taylor?
In
If
the
we have
event of
concerns that we can't see it, and then scroll down. People want to see the signatures. Yeah, thank you.
Yeah, I'll show the signatures after we get through the meat and potatoes here. So paragraph 1, in the event of a sale or exchange of the property above is made to a buyer produced or assisted by a buyer broker or sub-agent, seller has authorized listing broker to pay cooperative compensation to the buyer broker or sub-agent. Paragraph 2, listing broker shall pay cooperative compensation to the buyer broker in the amount of X. And paragraph 3 is the same. It's just addressing what compensation is being provided to a sub-agent. So the question we get is, logistically, how is this form, the best way this form is going to be used? And right now, we can't give you a straightforward answer on that. So really, we're going to figure out that answer once we provide this form to you and you all start using it. But it could possibly be maybe it makes the most sense for when you're filling out your listing agreement with your seller. And let's say your seller authorizes you to pay X% co-op to a buyer broker or X% co-op to a subagent. You can have them fill that amount in here. And so you have it ready to go. And if a buyer broker contacts you, you can say, yes, we're offering co-op, and send this agreement to them. Or it could make more sense if I'm a buyer agent or buyer broker, I'm representing my buyer. I know the maximum amount of compensation I can get for this transaction, which is my buyer in our brokerage agreement has agreed to compensate me X%. So I see a property my buyer's interested in. I can fill in this form. If I'm the buyer broker, I fill in paragraph 2 here, X%, and I send it over to the listing agent. If that listing agent has been authorized to offer X%, then they're going to sign it, send it back to me. If they've been authorized to offer less than X%, they're going to amend that amount and put in the correct amount. Or in the extreme, if they're not authorized to offer any cooperative compensation, they're going to tell you that and say, no, we're not going to sign this because we're not offering any co-op. These signatures. So the question we've got is, why is the seller signature on here and why is the buyer signature on here? So we'll start with the buyer. One of the main accusations of the lawsuit was that buyers were kept in the dark when it came to understanding the offer of co-op, or whether there was one and what that amount was. So for transparency purposes, we've added in the buyer's signature. So the buyer, when they're working with their agent, they can sign off on this agreement and they know, okay, for property, 123 Main Street, I know they're offering X% in cooperative compensation. Or maybe I know now they're offering nothing or something in between. The seller's signature, again, is added in for transparency purposes, so the seller can confirm that their listing agent is offering the correct amount of cooperative compensation that they authorized in the listing agreement. So if they authorize X% in the listing agreement and this says X%, great. If it says anything more than that, and this requires the seller's signature, the seller can say, whoa, no, I did not authorize that amount. And then they can properly, put in the corrective.
Yeah, and again, to repeat, this takes the place of the MLS, because as I mentioned earlier, the offer of compensation in the MLS is an offer, and the listing broker accepts that offer of compensation by procuring a buyer. That creates a contract. That's a legally binding contract. Because that is not going to be on the MLS anymore, this form takes its place. This is absolutely required so that there is a legally binding agreement between the brokers for compensation. And if you know anybody, or you do any commercial, or you know anybody that does any commercial real estate transactions, this is how they've been doing it for decades. There's no compensation offered in commercial MLSs. They have to, and if you've done any deals, excuse me, this. There's a letter of intent that the landlord and the tenant signed, and it's facilitated by the brokers. And at the bottom, it says, the brokers here, these are the brokers, and broker to broker compensation will be negotiated through a separate agreement. Every commercial letter of intent says that, because it's not embedded in their in the way they list and properties for sale or lease. So this is incredibly important to make that offer of cooperative compensation, assuming it's there in the listing agreement, and communicate it to the buyer's agent. This makes this binding on the brokers. It's very, very important.
And in my opinion, this is arguably the most important form, because what you're advising your buyer or your seller moving forward is really based on the offer of cooperative compensation. as we said earlier, the buyer broker agreement states the buyer broker shall attempt to secure this written agreement before submitting an offer for their buyer. Because if they get this agreement, buyer agreed to pay their broker X, and let's say they get this agreement from the listing broker, they're offering X. Okay, great. Now that buyer understands if I move forward with that property, I'm not going to have to pay anything to my broker. Or if it's the opposite and the offer of co-op is less, at that point, you can explain to your buyer, for this property, they're not offering X%. So we can submit our offer and you can request the seller to compensate me that excess amount, or that the amount of that difference. So this form is crucial to have this agreement in place before submitting an offer. It makes things much easier.
Yeah. So two things real quick. Question is, because I put in the chat exactly what you said, Taylor, about augmenting the IDX feed with the offers of cooperative compensation on the broker's website. I put in the Q&A, literally cut and pasted from NAR's FAQ. A lot of these questions also can be found, or answers to these questions can be found on facts.realtor. Facts.realtor. NAR has, gosh, I don't even know how many FAQs they have now.
90 or something.
108 FAQs at facts.realtor. A lot of questions you may have are answered there. So just to be clear, you may augment the IDX feed with the compensation amount, cooperative compensation amount on your broker's listings, not other brokers' listings. That is direct language from NAR, okay? So then we have the other question about the timing, and Taylor addressed this. And here's a good example of something that we don't know, how it's going to be resolved. We don't know where the timing is. We don't know exactly who's the best place to generate this. My sense is that if I'm the buyer's agent and I do know there's a co-op, and I also know what the buyer has agreed to pay me, as Taylor mentioned, those amounts could be different. What I am required by the settlement agreement to put in the paragraph 2 is the amount that the buyer has agreed to pay me. And it can't be any more than that, right, Taylor? Is that what you said?
Yeah,
so,
right.
And so the buyer's agent might be in the best position to generate this form. We just don't know. So you all are going to have to try this. We don't know. I'm trying to be honest. We have a lot of questions too. We know you have questions. Because this is so new and this paperwork has never been done. None of us have ever had to do this before. The market is going to tell us how this is going to work. And we're going to explore different ways, and some things are going to work better than others. And we're going to come up with best practices, but that's only through trial and error. We're going to have to say, this is confusing. This is how we think it should work. How does this flow between agents, etc.? Who goes first? What do I put in there? We can think and anticipate best practices. And I think we've agreed that the buyer's agent should probably generate this form. Timing wise, it can, hopefully be done while the offer's being negotiated with the seller, and definitely needs to be finalized by the time the buyer and seller are under contract, I would think. But again, because it's so new, we're going to have to try some things and see what works best. And we'll be in touch with you about all of that as it develops.
Okay, last form here that has been revised. This is our seller contribution addendum. And it's an existing form. I'm sure you're all very familiar with it. This is where the seller can agree to contribute to the buyer's closing costs. But we've added in kind of a disclaimer here, and it goes back to that conversation about interested party contributions. So remember, lenders have stated, as of right now, compensating the buyer's broker is not going to be treated as an IPC. So it's not going to count against that buyer's IPC cap. So we've added this disclaimer that states the parties shall use the seller contribution addendum to reflect seller's agreement to contribute to buyer's closing costs that are not related to the compensation of buyer's broker. The parties acknowledge that any agreement by the seller or seller's broker to compensate buyer's broker must be made through either the buyer request for seller's compensation of buyer's broker addendum and or the listing broker's offer of cooperative compensation agreement. And the main purpose of this is because if the parties didn't follow this, and let's say they just lumped in that offer of cooperative compensation, or maybe the sellers agreed to compensate the buyer broker, if they just lumped all that in and put it in this addendum, the lender's not going to know what portion of that amount should be treated as an IPC and what portion should not be treated as an IPC. So they're just going to treat it as an IPC, and it's going to count against that buyer's IPC cap. So in the interest of the buyer, if they don't want it to count against that cap, they need to make sure that any agreement to compensate the buyer's broker is contained in one of those two forms, or both of them. Okay, and the last, we don't really have to go into the details of our amendments because, you know, these are just reflecting the changes we just went over. But this is our buyer-tenant brokerage agreement amendment. We've gotten some questions from agents and brokers thinking that this is a draft version of the amendment. That is not the case. This is the final official version of the amendment. We've specifically added in an amendment key to note that any highlighted language is new language that's being added to your brokerage agreement, and any red line language is language that's going to be removed from your brokerage agreement. So again, this is for use where if you're currently representing a buyer or currently representing a seller, you can have them sign the right amendment. Then come August 14th, your brokerage agreement will be amended to be, you know, in line with the settlement agreement. And your buyer or seller is not going to have to sign a brand new brokerage agreement with you. Okay. That is all of our changes. Now we can get to some questions.
We're still getting some questions about the fact that this looks like a red line version. It is not a draft. What we really did not want you to have to do is sit with buyers and sellers and say, hey, here's the form you signed, you know, 4, 5, 6 weeks ago, and here's the new paragraph 8, for example, and then have to go line by line, word by word to see what's different. So we consciously did this. This is not a draft. This is the version to make it easier for buyers and sellers to understand what's in the amendments, and that you don't have to sit there and have a side-by-side, line-by-line conversation about what's changed. So we did this very purposefully, and you know, hopefully this is actually helping to have that conversation. We have gotten some questions about what the timing of this. If you have a deal that's going to settle well before August 14th, and you are confident that settlement's going to happen, then you probably don't need this signed. But settlements get postponed or canceled, so there's no harm in getting it signed because it doesn't take effect until August 14th, 12:01 a.m. on August 14th. So the worst that happens is it never takes effect. And yeah, you just wasted a few minutes of everybody's time, but on the other hand, you're protected. So if it's supposed to settle and you're confident it's gonna, then fine, I'll leave that up to your discretion, but just know there's no harm in it. Okay.
Let's go through some questions.
Want to stop sharing for now? There are some hands raised. I will say there are a bunch of hands raised in the participants. If you want to put something in, again, I'd rather do these, so put your question in the Q&A box, please. And if we don't, then I might call on people to ask the question live, but we'd rather not. So please consider putting your question in the Q&A box, and we are going to get to all. Oh, look, I have a 1 o'clock, but other than that, I'm here.
I
Let's
see a good question. The question is, so do we need both compensation forms, the listing broker's offer of cooperative compensation and the new buyer request for seller's compensation of buyer's broker addendum? The answer is no, you do not need both of those forms. The only scenario where your buyer might want to use that addendum is if the offer of cooperative compensation is less than what they agreed to pay their broker, and they're requesting the seller to make up that difference. Offers of compensation can be in agent remarks in a URL to office website. So Bright has said you can put a URL in the agent remarks section. You cannot say, for information on compensation, go to this URL. But you can put your URL in there, and if the agent follows the URL to your broker's website, on your broker's website, you can advertise your offer of cooperative compensation.
But not on the, you can say, see this website.
Right.
Here's actually an interesting question. It was from a while ago. If seller chooses to offer concessions and tell the buyer the amount, and the buyer can do with it what they want, that'll be displayed in Bright. So agents and consumers see it's an opportunity. Then why are they not? Or why are these forms? Well, it says then these forms are not necessary. That's not true, because as Taylor mentioned, seller concessions can be used to pay closing costs and or buyer broker compensation. So they are 100% necessary. The difference is, just to repeat what Taylor said earlier, seller concessions used to pay closing costs in general are subject to the IPC caps. FHA 6%, Fannie Freddie it's 3%, VA's 4%, I think, something like that. Seller concessions used to pay broker compensation are not subject to the cap. So that distinction's hypercritical for everybody to understand. And so those forms are absolutely necessary.
Yeah, and also that seller concession field on the MLS is non-binding.
Right.
So just because the seller says something on there doesn't mean they have a binding agreement with the buyer for that amount. So that amount has to be agreed to somewhere, and it's going to be agreed to using our forms.
Yeah. Let me just take another question from earlier. It says, are we still, quote, cooperating with other brokers? For example, sharing the listing commission. This is a fundamental misunderstanding in this business. Cooperation has nothing to do with compensation at all. And if you please reread that section of the listing agreement that defines cooperation as nothing more than sharing information about my listings to other brokers. That's what cooperation is. And it's clearly spelled out in the listing agreement. And you read the code of ethics, it makes it abundantly clear again that cooperation, sharing information about my listings, has nothing to do with compensation. So we call it cooperative compensation. I think that's unfortunate, but that's the words we use, or co-op. So cooperation, sharing information about my listings. Compensation is compensating the buyer's broker for procuring the buyer. So if you're confused about that, it's because you haven't internalized the difference between cooperation and compensation. And that's what you should be explaining to, especially to sellers, about, yeah, we're going to put this in the MLS unless it's an office exclusive, but we're also going to have a conversation about whether to compensate the buyer's broker. So please keep those two things separate.
I had a question about the brokerage agreements and when they're available. They are not available right now. They will be made available for use on August 14th, because on August 14th is when offers of cooperative compensation are being removed from the MLS. And we've, edited our brokerage agreements accordingly. So on the 14th, they will be available.
I think we've answered a bunch of these. I'm starting at the top.
Yeah,
Why don't you start at the bottom? 'Cause some of these from
432 questions right now.
So from 10 o'clock, I have some, but I think I think we have answered most of these from 10 o'clock. Oh, here's a good one. Can I also post my listings on reac.homes, a real estate commission.homes? No, 1,000 times no. There are people who are purporting to establish websites that act as clearing houses for compensation offered by brokers. Do not, under any circumstances, put your offers of compensation in any of those sites, and do not look at those sites for any purposes. Follow the procedures we have outlined for you. Check the website, call the listing agent to determine if there is a co-op being offered. Do not participate in those aggregator websites. I promise you, those are going to be shut down very, very soon. So be careful, please be careful. You talked about sub-agency. That. If the buyer's fee is less than the co-op, and the intent is for that savings to go to the, not to go to, or to the seller, not the listing agent. Well, that's actually, did we talk about that?
Sorry,
What
what
if,
was the question?
well, so let's say the buyer, the co-op being offered by the listing broker. Oh, no, is less, is more than what the buyer representation agreement is talking about. And we talked a little bit about having a policy about amending the buyer representation agreement upward, right? So what if I decide as the buyer's agent, what if I decide, no, I'm happy with what I negotiated as far as my commission with the buyer, right? I'm happy with that. But the seller, or actually the listing broker through the seller, is offering a higher amount. And in my zealous representation of the buyer client, I may not want to let that money just stay on the table, right? Because the seller, in my mind, has already parted with that money. So isn't it an option for me to discuss with the buyer the potential for requesting a seller concession for closing help that represents that difference, and that, so that benefit inures to the buyer through like a seller concession, a closing help? Did you understand? Did I explain that right?
Exactly.
That's okay, right?
Yeah.
And so you just use the seller concession form, not the one for broker compensation, right?
Right.
Okay, there's a talk. Okay, some of these are old and I think we've answered them. Some of these are still back from 10 o'clock. Does not have an IDX. Okay. Oh. I'm going to go to the bottom. I think we've through the middle of the section. Yeah.
Question I see, can the percent be a range for the buyer agency agreement that would account for anything in the range? And the answer is no, because the settlement agreement specifically states compensation cannot be open-ended. And actually NAR's FAQ site specifically says ranges are not allowed.
Yeah, and there's one about the buyer, not having the ability to compensate you. That again, that's a question that you have to answer ahead of time, right? These conversations with buyers, once again, brand new for us. We haven't had to have these conversations with buyers in the past. And that's why we took the easy way out a lot of times, right? We put in 0 or per MLS in the buyer representation agreement because we didn't want to spook the buyer that maybe they would actually have to pay us. And so there's an expectation in the marketplace, right? Consumers have received almost nothing but bad information, right? Let's like make that clear. Your job has been made incredibly more difficult. Our job has been made incredibly more difficult by the degree of misinformation that's gone out. I mean, I have not read a single article yet from what I would normally have considered reputable news sources that are not filled with misinformation. It's just a fact. It's unfortunate, but it's happened. And so here we are now dealing with the fallout because consumers are very confused. And they just don't know. They think we work for free. They've seen those signs. Oh, this spells the end of the 6% commission, or even that the settlement agreement eliminated the 6% commission, whatever. And I'm just quoting here. I'm not suggesting, speaking of antitrust. But what I am saying is that our jobs now are, number one, to understand this ourselves, and number two, to understand it well enough that we're able to communicate this information to consumers of many degrees of ability to understand what we're saying. And that we have been recommending from day one that we practice this, that we get in front of each other and we role play and we share the communication that we've had, the questions, the confusion, and figure out different ways to communicate this information based on the ability of these consumers to understand it. Because you could have a PhD, you could have an attorney, you could have somebody who has bought and sold many times. You could have somebody who it's their first time, a first-time buyer who it's going to take a lot more sitting with them and explaining to them over and over again, or using different words, whatever it takes to get them to understand it. So our jobs are made incredibly more difficult by this settlement. And the best we can do at this point is give ourselves a chance to really internalize it, to get to know the new forms, to figure out how the paperwork's going to flow, but to understand it well enough so we can explain it to people for whom this is brand new and they may have no idea what we're talking about until we've sat with them for a pretty significant amount of time to get them to a point of understanding. So, we know this is a daunting task. We really do. And that's why we'll stay here as long as possible to see if there are any additional questions that we haven't answered yet. Yes, the answer is if you are on this, you will receive a link for the replay. Yeah, absolutely. And there's a lot of questions about buyers and tenants. If you go to the very beginning of all of our brokerage agreements, the buyer is buyer tenant. It says buyer includes tenant. Okay, so when we talk about buyers, we mean tenants. Now we have a different listing agreements, right, Taylor?
Yeah.
Whether it's a right to sell or right to lease or an unapproved land. But all of those brokerage agreements are being changed to make similar changes to all of the different representation agreements, and the amendments work no matter what. On the seller, lease, or unapproved land, that one amendment serves all those purposes. But on the buyer side, buyer means tenant. It's stated at the very beginning. So yes, that could apply on a lease or a sale.
I've seen a couple questions about if my buyer broker compensation is X and the offer of cooperative compensation is less than that at Y, can the broker decide to waive the difference, essentially accept less compensation than what's stated in their buyer broker agreement? So like Chuck said at the beginning, the settlement agreement does not address amending compensation upwards or downwards. It's really that broker's individual policy, whether they want to allow their agents to agree to lower the amount of compensation that broker is going to receive.
And we hear a couple of questions about, listing agents have said they will not say whether there's compensation or how much there is. That's unfortunate. And they're not serving their clients. So if you have a listing agent, you check the website, there's no compensation being offered on the website. You just want to be sure. If you contact a listing agent and they either refuse to return your call or refuse to say yes or no, it's a simple yes or no. Are you offering a co-op? Did the seller authorize it in the listing agreement? Yes or no? Whether there's, the amount or not, the simple fact, they can't refuse to answer that question. They really can't. They're violating Maryland law, the code of ethics, and they're not representing their clients. They're not acting in the best interest of the seller by refusing to answer that question. And if they either are not responsive or they're refusing to answer, call their broker or manager and insist on an answer, because it's a yes or no answer. There's no reason for people to not answer that. And any listing agent that refuses even to answer the question is violating Maryland law and the code of ethics, because they are not protecting and promoting the best interests of the seller. That's a simple answer. All of these apply only to residential properties. Question was about commercial. The settlement agreement does not apply to commercial transactions. I'm going to go to the bottom, see what I missed. Yeah, so there's a question, if it doesn't impact a buyer loan qualification for an IPC, then seller concessions is the easiest way and the buyer can choose what to do with them. Well, yes and no. The buyer can choose. The answer is yes, of course they can, but they have to choose whether it's just closing help or whether it's compensation. So that's why there's two different forms, one for closing help and a separate one for compensation. So those two things have to be discussed at the same time, but separately, because the seller closing help is subject to the IPC cap. Seller concessions used to pay buyer's broker, not subject to the cap. And let me just say, take a step up, talk a little bit higher level. As many of you know, if you work in different parts of the country, or different states, I should say, you're going to see different forms. Some states and even local associations who publish a listing agreement have taken cooperative compensation out of their listing agreements entirely. We know California did because the DOJ was breathing down their necks. I'm pretty sure I was told that Delaware took it out. Northern Virginia took it out. GCAR took it out. Maryland Realtors did not. And so, first of all, we made the decision here at Maryland Realtors, the statewide forums committee, the executive committee made the policy decision that the market will tell us. Consumers will tell us. You, our members, will tell us whether cooperative compensation is a viable option moving forward. How often does it get used? How easy is it to understand and explain to sellers? If we find 6, 9, 12, 18, 24 months from now, who knows, that cooperative compensation is not a real viable option, then we'll revisit that decision. That's just a simple fact. But Maryland Realtors did not want to make that decision for our members and for the consumer, because it is 100% still allowed under the settlement agreement, just can't be in the MLS. So Maryland Realtors decided to keep it in our listing agreement as an option for you and consumers. And you will know, because we'll ask you, we'll make surveys, we'll send out surveys and over time and track this. And we'll know the degree to which it's still a viable option. And if sometime down the line it's not, and it's not being used, and it's really all about concessions and ultimately the buyer's paying, then those policies will be adjusted accordingly. But we didn't want to jump ahead not knowing what that was going to be. It's still an option. It's a viable option. NAR and many of us think that it's still a big benefit to buyers and sellers to still have cooperative compensation as an option. Okay, so just wanted to clarify that. Yes, the RPR session at 1 o'clock will also be recorded, but I'm pretty sure we'll be done by then.
I saw some questions about subagency and why a seller should offer to compensate a subagent. First of all, that's offering cooperative compensation. Like Chuck said, when you get to that point in your listing agreement, you explain the pros and cons of offering cooperative compensation to your seller. And if they want to offer it, at least in my mind, why would they care whether a subagent helps them get a buyer or a buyer broker helps them get a buyer? So if they're going to agree to compensate the buyer broker, in my opinion, it just makes more sense to offer the same amount to a subagent, because at the end of the day, the seller doesn't care who's purchasing their home. But again, that's the decision for the seller to make.
So there's still some conversation about the additional compensation, no matter what you call it. There's a question, what do we label it? Nothing. It's compensation. It says right there, this is the amount of compensation that I am earning as the listing or the buyer's broker. X% plus X dollars, period. It doesn't need a label. It's already labeled. It's compensation. Do we see Maryland removing dual agency and going to a transactional brokerage? Todd, I'm glad you asked that question. I would love that. I've been, for almost 20 years now, I've thought that we have made this ridiculously and overly complicated and complex. I have never really believed that agency as we know it even belongs in real estate. I mean, these are adults. It's a holdover, I think, from a patronizing view of this transaction. These are willing adults who are making decisions, and I don't see any reason why I shouldn't be allowed as a professional to broker a transaction, to bring a willing buyer and seller together in a non-agency relationship, in a transactional brokerage relationship, and represent nobody. Just help them get to settlement. They have it in a lot of states. We don't have it in Maryland, but I can tell you we are looking into how they do it in other states, and you might actually see legislation in the 25 General Assembly session here in Maryland to bring transactional brokerage to Maryland as an option, not necessarily that all and every transaction has to utilize it, but to me, the fact that it's not even an option in Maryland is something we absolutely need to address. And a lot of this conversation becomes a lot simpler, especially if these are sophisticated buyers and sellers. They don't need us. It's kind of patronizing when you think about it, that they just need somebody with the ability to put forms together to, talk about and negotiate and help the parties negotiate back and forth, and be the conduit. And I hope that's an option for us at some point, but we'll keep considering that. Yes.
I saw a question about, I guess I'm going to generalize it, advertising cooperative compensation outside the MLS. Whether you can just say, co-op offered, or you can state a certain percentage. That is your brokerage's, policy decision. You're free to state exactly what percentage you're offering, or you could just say, there is co-op being offered for this property.
Yeah. So there's a question here. DOJ says offer of compensation should not be made anywhere. They can say whatever they want. The DOJ is not a party to the settlement. They're not. I said very early on, we know what they want. We know what the DOJ wants. And they might get it. I don't know. But nobody cares what the DOJ says anymore. Right? I mean, that's not true, but you know what I mean. They're not a party to the settlement. So we're not taking an opposite stance. We're complying with the settlement agreement. The antitrust case went to the jury returned the verdict. NAR entered into the settlement agreement with the plaintiffs, and we are implementing that. The DOJ has its own investigation. We know what they think, but until they come out and there's another kind of settlement, and all of this goes away at some point, and maybe in our lifetime, maybe not, I don't know. It's already been going on for 10 years, so who knows? But it's not right to say that we're taking an opposite stance. We are taking the stance, and we are proposing our policies in full compliance with the settlement agreement, in full consultation with NAR. Well, I'm not even gonna talk about it. Companies are gonna make their own decisions. Look, every company is gonna be different. And if company policies change, they don't have to follow our guidance. Let me put it this way. Every company, every firm is entitled to make their own decisions. And if they want to follow our guidance, great. If they want to do something different than we are recommending or suggesting, great. And I said it a couple times, I'm going to say it again. Every company in consultation with their legal counsel is going to make decisions. And they could very well be decisions that are different from the positions we have taken. But I will say, and I'll repeat it again, we are 100% confident that everything we have said today and in the past and in the future is signed off on by NAR and is in compliance with the settlement agreement. Yeah, so, there's another question about amending the buyer's agreement that deserves repeating. If the seller offers compensation, whether it's a bonus or whatever, that's higher or in an amount that exceeds the amount in the buyer's representation agreement, our position at this point is that the settlement agreement does not prohibit that practice. We are also saying that because we are under such scrutiny, we would advise you to take that very carefully and a considered policy. And this was a broker who asked this question. So your company policy will dictate whether your agents have the authority from you to renegotiate that buyer representation agreement higher than what you have already agreed to. And if you make that decision, you must be very, very careful that your attorney has signed off on it, that is a practice that your attorney agrees with you implementing. All we're saying is that amending the buyer representation agreement to reflect a higher amount, whether it's because of the co-op or a builder bonus or whatever, that's up to you. The settlement agreement does not expressly prohibit it. And that's all we're about. That's really all we're saying at this point. Yeah, and then this person just said, yeah, will it fly with intelligent clients? Well, look, if you go in front of a buyer and say, hey, I know we agreed to this, but I have X amount of dollars coming from the builder, okay, can we amend this agreement so I can make more money? What does that negotiation look like? So again, and that's all I'm going to say. I really do. But you have to think this through, please, before you make any decisions about your position vis-a-vis amending the buyer representation agreement to allow you to accept an amount higher than what the buyer has already agreed to pay you. You need to really think that through. You know, what is the buyer's reaction going to be when I bring this up to them? And if you're happy with that and your buyers are going to be, oh yeah, sure, you know, that's great, great. All we're saying is not prohibited under the settlement agreement. Your company policy is what it is. Just make sure you've consulted with your attorney first. Okay, if somebody's looking for the brokerage agreement amendment, it's on our website. It's been, just please go to our website and you'll find it there.
Specifically, it's under the statewide forms page. So that's where
Okay.
all of the forms are and amendments are.
I've seen a couple questions. The scenario where a listing agent is, working with an unrepresented buyer for the transaction. Keep in mind that our listing agreement, paragraph 14, is the total amount of compensation that the seller is going to pay to that listing broker. If the seller also, let's say, authorizes the listing broker to share a portion of that with a buyer broker, and you're working with an unrepresented buyer, then you're not going to share that portion with the unrepresented buyer. And the way our contract is set up, the listing agent, listing broker, gets to retain that full amount of compensation in paragraph 14.
There's a comment here about the agent remarks, including the URL. I heard a Bright representative say that a listing agent can put a URL in the agent remarks. Nothing about compensation, nothing, just the URL that points the buyer's agent to that website in order to determine whether there's cooperative compensation being offered. So all I'm doing is repeating, but very early on, we probably should have said, we don't speak for Bright. There are some questions here just about Bright, and you need to, those questions should be answered and asked of Bright. But I heard a Bright representative say that the agent remarks can include a URL that the buyer's agent can go to. The site should not be linked to in the agent remarks. Well, look, I'm sorry if there's confusion, but I'm just repeating what I heard, and I know I heard it, and I asked it to be repeated. So I'm sorry if there's confusion, but I can only repeat what I heard. And there may be a nuance in this that is missed, but that's all I know. Does the title company need a copy of the buyer representation agreement? No, the title company will need to see, if it's a co-op, that they will need to see that agreement between brokers. Yes. And they'll need to see the contract if there's concessions. Yes. And if there's a difference between all of those and what the buyer has agreed to, then that's going to be a conversation between the buyer's agent and the title company that they need to make up the difference at closing.
Questioner, I have sellers that don't want to specify an amount they want to offer until they get an offer. Can we just ask that the buyer's agent submit their request with the offer only? Well, if the seller doesn't want to specify an amount, then they're not going to fill out paragraph 15, authorizing the broker to share that amount of cooperative compensation. So in that case, yes, the buyer would submit their offer and request the seller to compensate the buyer's broker. I see another question about that reac.homes site. And like Chuck said, our strong recommendation is any website that is trying to compile all different brokers and putting offers of co-op on that site, we recommend not putting anything on those types of websites. Because, I mean, essentially, they're trying to create an MLS without calling it an MLS.
So here's two questions. Can you have a buyer broker agreement for each property shown if consistent? I mean, there's nothing prohibiting that. I don't know why you would. But I don't believe there's anything illegal about that. Can I charge an unrepresented buyer as a transaction broker if I'm the listing? Well, first of all, listing agent, no, brokers charge, not agents, but no, you know, under Maryland law, you have to have a client and your client pays you. And we have dual agency, single agent dual agency in Maryland is illegal. So I think we need to anticipate somewhat of an increase, I think, unfortunately, in unrepresented buyers. So we need to be really careful about that. If buyers say, I don't even want to have this conversation, I don't even want to be confronted with the notion that I might have to pay a broker, I'm just going to call the listing agent. And we can do that today, right? It's a thing, even today. An unrepresented buyer calls you on your listing, you've already agreed what you're going to get paid by the seller. If an unrepresented buyer contacts you, you know, if you are allowed to, first of all, make sure they're not party to an exclusive written representation agreement. Number two, that you have given them the understanding who real estate agents represent form, alerting them to the fact that you are the seller's agent, just the way it is today. And if they love that house and want to see it, you are allowed on their behalf to perform ministerial acts. Two things. First of all, it's a trap because buyers, unless they're sophisticated buyers or investors and who know exactly what they want, if they're just doing it to save money, they're probably not going to know how a contract is formed, what goes into a contract for sale. And they're going to want to have you actually help them. And that's illegal in Maryland. That's undisclosed dual agency. If you step over that line and perform anything but a ministerial act, you could lose your license. And what ministerial acts basically are filling in the blanks of a contract. Here's the contract. Here's a blank line. What do you want to put in it? From the sale price to the addenda to whatever contingencies, you are not allowed to tell that buyer anything about the pros and cons of doing or asking for anything. And so, you know, that is for many buyers, that's going to end up being a bad situation. And ideally, they get frustrated enough and then realize that they actually should have professional representation, and maybe then you as the listing agent refer them to a buyer's agent in your office. That's a good outcome. Other than that, you can't charge the buyer. They're not your clients. And so, you know, I've had other questions like, well, so suppose can I charge the seller more if I'm helping an unrepresented buyer? that I'm gonna leave up to your company policy and how you can work that out. I'm skeptical of it. But again, in the perfect world, if you're following the law, let me put it this way. If we follow the law, an unrepresented buyer should not be that much more work for me. All I'm gonna do is sit there and fill in the blanks of an offer and submit it to the seller. So really shouldn't be a lot of work on our behalf, on our part. I think it's dangerous. I really do. So approach this very, very carefully and talk to your broker or manager. If you're in that situation, especially for the first time, there are some traps there, and I don't want you to fall victim to. So please be very, very careful, very, very careful. So there's a question here that says we're not answering their question.
I think that was from Karen. I think I did answer her question.
Oh, okay. Great. Seller listing broker be requiring to see the buyer's agreement in order to consider the seller offering additional no. No, this is a negotiation like any other. So there's not, the listing broker is never going to see the buyer's agreement. No. And Pennsylvania has different, yes, we know that, but and Pennsylvania did preserve cooperative compensation, by the way, as you probably know.
Linda said, I don't feel like you explained the rules on having a buyer broker agreement signed prior to showing a home. So yes, per the settlement agreement, actually in, per Maryland law since 2016, before showing a home, you have to have a buyer broker agreement in writing signed before doing so. If the buyer does not want to sign the agreement, then you can move forward as a subagent by providing them with the understanding whom agents represent form.
Yeah, how about a FSBO? Nothing's changed regarding a FSBO. So if you are representing a buyer and the buyer finds a FSBO or you find it or whatever, nothing's changed. You have the agreement, what's it called, Taylor? Authority to show and compensate the broker. We have a form for that, right?
Yeah, authorization to show and pay buyer
Right.
broker, I believe.
Right, something like that. So nothing's changed at all from the current procedures and process for a FSBO. That's not at all, again, assuming that there's compensation. Now, the compensation, if the buyer and you and the buyer want to get the FSBO seller to compensate you, then a lot of those conversations about compensation are in play. But overall, no, that it's the exact same conversation and the same process that you would use today. So this, let me, as a seller's agent, we have a responsibility to sell the home, correct? So the listing agent must write the offer for presentation, correct? Yes. The seller could sue the agent. Yes, I'm yes, 100%. If the buyer, this is an unrepresented buyer, and you're doing your due diligence and you are protecting and promoting the seller's best interest, and there's an unrepresented buyer presents themselves and wants to write an offer on your listing, yes, absolutely, you must do that with the operating under the constraints of Maryland law that you may only provide ministerial services. If the buyer asks you, okay, it's listed for $450, will they take $400? Your only response is, I don't know. You are required to tell me what you want me to put in the offer price. Is a blank line. What do you want me to put in there? I am not allowed to give you any advice. I'm not allowed to help you. I'm allowed to fill in the blanks of this contract. And if that buyer walks because they're frustrated and you can't find a buyer's agent for them, either in your office or outside of your office, You're not violating your duty of loyalty to the seller. No, you're not. You're complying with Maryland law. Let's be real clear about that. And I'll be honest with you, I have no sympathy for unrepresented buyers. If they make a choice to be unrepresented in one of the most important financial transactions and life transactions that they will ever engage in, and they choose to do it without representation, I don't have a lot of sympathy for them. My sympathy is with our members so that we do nothing but that creates risk for us. So follow the law as we know it and perform only ministerial acts. The seller cannot complain. If that buyer walks, that is not your fault. Do not engage with that buyer just because you think you have to sell the house. You're putting your license at risk. So be very, very careful about that. I've already answered anything about admin fees. I'm not, that don't exist. So don't do it. It's compensation. Why is the buyer agency agreement so adamant? The settlement agreement requires it. And Maryland law has required it since 2016. So it's get the buyer agency agreement signed. We've always taught that you should have it signed before you walk out the door. And we've always said from day one, we have said, look, if the buyer's not willing to commit to you, have a 1-day agreement, have a 6-hour agreement, have a 1-hour agreement. But have a written buyer agency agreement signed. Otherwise, you're the seller's agent. So, get that agreement signed. Touring agreement. No, I'm sorry. There's this thing out there called the touring agreement by a company who shall not be named. That is not a compliant brokerage agreement in the state of Maryland. Do not even think about using that touring agreement. It is inconsistent with Maryland law. Do not use it.
We actually have an article about that on our website.
And we do.
Question, can you review the difference of the seller contribution addendum and how the lender is fully aware that the IPC? I'm not clear on where it's clear to the lender. So we've added the disclaimer to the seller contribution addendum that if there's any agreement to compensate the buyer's broker, if the buyer wants to ensure that that amount is not counted as an IPC, then they're going to put that amount in either the new addendum or the listing broker's offer of cooperative compensation. If they just lump everything into the seller contribution addendum, the lender's not going to know what portion should not be counted as an IPC.
So I was been told that I gave wrong advice. I would stand by my advice. Your job as a listing agent is to quote the list price and fill in the blanks on the contract with what's in the seller's best interest unless the buyer tells you to put something different. I 100% disagree with that. Your job and a ministerial act is very clearly defined in Maryland law. Your job is to point out the blank line to the buyer and say, what do you want me to put in here? That's just how we have always taught it, and I stand by that advice. If we refer an unrepresented buyer to the listing agent, who refuses to sign a broker agreement, well, they can't sign a brokerage agreement with the listing agent because that's illegal in Maryland. That's dual agency, and we don't have that. Unless anything, I can rightfully ask the listing agent for a referral fee. No, that's if an unrepresented buyer refuses to sign a brokerage agreement or understanding whom agents represent, and the listing agent ends up writing a contract for a buyer, they're not a client. There's nothing to refer. You haven't referred them a client. Referral fees apply if I refer something to another agent who becomes a client of that agent. I can request a referral fee. Under that situation, that's not a referral, and there is no fee to be paid because there's been no compensation earned on the part of the listing agent for helping perform ministerial acts on behalf of an unrepresented buyer. So no. Transactional broker, no, we don't have transactional brokerage in Maryland. I wish we did, and I hope we do. I said flat fee compensation. If that would not fly with intelligent, I'll leave that up to you. I'm just telling you what the CFPB has had in their analysis and their application and enforcement of the Real Estate Settlement Procedures Act. RESPA very clearly says what I already said. So that's, I don't feel the need to belabor that. Well, I'll agree with the anonymous who says the DOJ doesn't really seem to have buyer's best interest in mind. Yeah, I think a lot of us would agree with you. And the Consumer Federation of America believes the same thing. They believe, as the plaintiffs argued at the trial, that buyers should be face-to-face with their brokers, negotiate compensation, and that commissions are going to go down. And because if the buyer had to pay it out of pocket, they'd be way more concerned with how much you were earned as a buyer's agent, and that I had to use my negotiating skills to talk you down, and therefore housing magically becomes more affordable. And the jury believed that. For some reason, the Department of Justice believes that. The Consumer Federation of America believes that. A lot of us who have been in this business for a long time don't necessarily believe that. So, yeah. So there's a question. If the listing broker's offer of compensation is higher than what's the buyer is, can a buyer specify where the balance? Yeah, we did answer that. If the compensation is more, then we recommend, and I know we said this, that the buyer's agent confirm with the buyer whether they want or offer them to submit an offer for seller help to make up that difference. So if the listing broker is offering X%, but the buyer representation agreement is 0.5% or 1% less than that, rather than leave that money on the table, absolutely, the buyer has the option, and you should explain this to the buyer. They have the option of asking for seller closing help to make up the difference. Absolutely. And I know we talked about that a little while ago. Barry Hess, I love you, man. We are not talking about procuring cause here because we're running out of time. Call me, Barry, if you want to talk about procuring cause. Happy to talk to you. The listing agent referred the buyer to a buyer agent. Can there be a referral fee? That's up to you. The answer most likely is yes. And I think it happens all the time. So that, again, is up to you and the other agent, if it's in your office or the other company, to negotiate. If the buyer does not want to see houses with no buyer agent compensation, then what do you write? Actually, that's a good point. I wouldn't put it in the brokerage agreement, but if you go back to my conversation about the 4 listings, if the buyer says, I don't want to see any houses where I'm going to have to ask for concessions because that's unknown and I don't want to negotiate that, I only want to see the houses where there's a co-op, and you have 4 listings. Thanks for that question. Absolutely, 100%. Get the buyer to confirm in writing that they made the decision to not see these 2 houses because there's no co-op. That is 100% their decision, and our responsibility and our job to comply with the settlement agreement is to not make those decisions for them. That's what steering is. So to avoid any allegation that we are still steering buyers, make sure that the buyer signs that they made the decision to not see those houses, that was not your choice, that was their choice. Get it in writing and keep it with the file. Very good question. Thank you. all sellers have current listings, need to sign the new forms. Yeah, I think we're saying, yeah, I think it's easy enough to just sign the amendment, if I'm reading that question right. Do they have to sign the offer of co-op even when there isn't one? No, you only have to do it when there isn't any. Okay. Where would they sign? It's up to you. It's a good question. Where would they sign that they don't want to see homes with no co-op? Right on the form or some separate form that you've created. Anywhere you get it in writing. We don't have a form for that, but you will be able to figure that out somehow, however you think it's best. Just get it in writing. I chose not to see this property, initial here, something like that. Yeah, Kelly has to go and I have another meeting that I have at 1 o'clock. Is it, or 12:30, excuse me. If you're working with a buyer, on Herbs, if you're working with a buyer that sees a property before and there was an offer in Bright and the seller's still bound. Yeah, actually, Herb, no, yes and no. No, unless an offer has been submitted, because remember the rule. If I submit an offer to purchase on August 13th, and that offer is accepted, even it's after the 14th, that you have accepted that offer of compensation. That's in Bright. Do you agree with that, Taylor?
Yes, but I would also, just to protect yourself,
Yeah.
also get the listing broker's offer of cooperative compensation agreement signed in addition. Chuck, Kelly said she can't work on the next webinar. Yeah.
I saw. What did she say exactly?
Sorry, guys.
So
I'm just
That's
saying
okay.
I've got the RPR webinar at 1 o'clock and we have a practice session before
Oh, I
that.
see what you're saying.
Mm.
All right,
And-
well,
yep.
we're gonna have to sign off. We're down to 640, so we've lost about half of our participants. So let's sign off here. That was an amazing, I think there probably are questions, well, unfortunately, we didn't get to. We had 1,300 people on. We had a couple hundred questions. It stops counting at 99, so we don't really know.
There was
If we-
over 500 questions.
So if we did not get to it, please email us, call the hotline or email us, me or Taylor directly. We will be here. If you want us to come out and visit your offices and go over this stuff again, we're happy to do that. We've done dozens and dozens of them. And again, just know that we are here. We're working as hard as we can to help everybody get through this. And please let us know how we can do better. So Taylor, thank you. Any
yeah,
any
thank you,
words of
everybody.
wisdom?
And if you have any, like Chuck said, if you have any questions, please feel free. Call us on the hotline, email us on the hotline through our website. That's probably the most efficient way.
Okay.
Yep, and just so everyone's aware, this webinar was recorded. It will be sent out to all registrants and up on our YouTube page as well as our website. We'll make sure it's posted there as well. If you do have any suggestions, we do have an email inbox that is shared. It's suggestions@mdrealtor.org. So you can also email that. But we will make sure that everybody who was registered today has a copy of this presentation.
Okay, thanks, everybody. Keep up the good work, and we're here for you.
Thank you. Bye-bye.
Thanks. Thank you, Kelly. Thanks, Taylor.